Hello, everyone. How's it going? This is immigration attorney Moumita. I'm coming to you live to talk about immigration law. For those of you who are watching me for the very first time, my name is Moumita Rahman, and I am an immigration lawyer. I have been practicing since 2010 with my own practice, and it is my pleasure to do the work that I do because I strongly believe in immigration rights and that immigrants make America great already. All right. So thank you for tuning in. Please make sure you drop your questions and your comments in the box below. And make sure you come and say hi. Let me know where you are, what city and what state or what country you're in. I have so many viewers and I love to see where they are from. So again, thank you for tuning in. I wanted to talk a little bit today about the I-360 VAWA process and how long it takes, what to expect, what you need for this process. Now, for those of you who don't know, the I-360 VAWA application is for multiple categories of people who are in relationships with family members that are not treating them well. And it is a particularly powerful way to get a green card if you are eligible, or at least to obtain deferred action and protection against deportation and get a work permit. So the majority of cases that I do underneath this law are for spouses of U.S. citizens or of spouses of green card holders or parents of 21-year-old U.S. citizen children. And in these relationships, there has been a lot of extreme cruelty or physical battery. And when I say extreme cruelty, I'm really talking about certain sorts of immigration, certain sorts of emotional issues and emotional manipulation that's occurring between the U.S. citizen family member and also between the immigrant parent or the spouse. And it is really, really important to know about this case because this sort of a case, helps people to get a green card if they qualify for it. Also, one of the key things and key benefits of this sort of a case is you don't need to have a legal entry. You don't need to have a legal entry, or if you have certain sorts of issues, you may be able to get it waived. So for this sort of a case, the thing to know is this. You need to have your identity documents. You need to have proof of that relationship, whether it's through a child or through marriage. You need to be able to establish this. If your case is based on a marriage, you need to be able to prove that you married your spouse in good faith and that you have lived together in the same physical location. This is a very key and actually maybe one of the hardest things to prove in a VAWA case. Next, you need to prove that you have suffered either extreme cruelty or battery in your marriage or with your child, or sometimes you can also do VAWA if you have a U.S. citizen parent and you are a child who is in need of a green card. So you have to prove that certain things happened, and many people believe that you need to have a police report. Many people believe that you need to have pictures of bruises and things like that, but that's not actually true because the law actually carves out that VAWA can be used for persons who suffer extreme cruelty. And as I mentioned earlier, extreme cruelty is when you have suffered emotional abuse. All right. All right. So those are the key things that you might need. Now, what to expect when you file for VAWA? One of the most important things that you receive in the mail within the first few months after filing is something called a Prima facie determination. And this is a really important letter because number one, it does help establish that you have met the basic eligibility criteria, although it's not yet an approval. To me, it's a strong indication that you're going to get your case approved. Next is the fact that this letter is also protection to show that you have this application pending, and it will give you a little bit of security should you be worried about ICE picking you up. Next, this letter may also make you eligible for certain benefits with the government in the state that you're in. You have to check to see what your state laws are, but in some places you can even get a driver's license with this letter. In Florida, for example, and in some places you can get certain healthcare and other things. But once it's filed, once your case is filed, you should expect to receive this prima facie determination within about anywhere from 3 to 5 months after your case is filed. I'm happy to report we're actually receiving them pretty quickly since the past month. A lot of things are moving very, very quickly in the VAWA land. Next, if you were eligible to file for a green card application along with your VAWA, then you would also receive your work permit. Your work permit would usually come in about, I would say, between 5 to 7 months after your application is filed. That's how long that we are currently seeing for these cases. And then the actual self-petition for the I-360 usually takes anywhere from 18 months to about 2 years to be approved. Once it's approved, then if you are eligible to apply for a green card and you have already filed your green card application with us, then normally you would be waiting up to a year or maybe less, maybe a little bit more, depending on the field office that you are assigned to. So that's just a general breakdown of that application process. And again, you know, I get a lot of calls from people who have started the green card process with their US citizen spouse. The spouse is wanting to pull out, the spouse doesn't want to continue. I also get a lot of calls from people who are looking to see what their options are because they've been told that, you know, they need to have a waiver to leave, or maybe they even started the waiver or the perdón process to go outside the country and to come back, but their spouse either doesn't want to continue, or they're having problems in the marriage, or they're worried about leaving and what will happen if they leave. You know, will they be able to come back? Now, this is why this application is a very, very important thing to explore with the client, because it may not be necessary for them to leave the US and they may be eligible to file for the green card stateside here. And also if they have, let's say you're a person who's already started the application process for a green card and your spouse and you are having troubles, your spouse is threatening you in many different ways, then this is something that you want to talk about. So you can give me a call, 212-248-7907. And I'm going to go ahead and answer some questions right now. And thank you to everyone who's watching. All right. So let's see. I have a question from Hassan, who's asking, is a U visa going to be available for brothers and sisters of U.S. citizens? I'm not too. So you know, if you're a U.S. citizen and you have a sibling who you're trying to help petition to come here, the most important thing for you to understand is this. The wait time for siblings of U.S. citizens is extremely long. The wait time is about 10 to 15 years, and for some countries, it's even longer. So not only would your sibling need to wait that long to be eligible for a visa number, but also if they're already inside the U.S. and they're looking to get the petition done with the brother or sister who's a U.S. citizen, if you're already in the U.S., you need to be in status. If you're not in status, then you're not eligible for the adjustment of status process, which means that you would need to depart the US to go to your home country for an interview at the consulate. But the problem with that is this. If you have been in the US for a number of days, that is basically considered unlawful presence, meaning that you were not actually permitted to be here, then if you have more than 1 year of unlawful presence, the minute that you leave the US to go for your interview at the consulate, you would trigger what is called a 10-year bar. Now, the 10-year bar may be waivable. In some places, you may be able to do the waiver or the perdón to waive it, but you need to have a qualifying relative. And the only two types of qualifying relatives that you can have for the unlawful presence waiver is a spouse or a parent who's a U.S. citizen or a green card holder. This is why, you know, when people come to me and say, I have a brother or sister who's a U.S. citizen, can I get a green card through them? I say, well, yeah, you can, but it's going to be a very long and difficult process. And the majority of cases that I see where a sibling petitions for a sibling is usually when the sibling is already outside the U.S., so they already have a life, and, you know, basically 10 years down the road, all of a sudden they learn that their visa is finally available, and then they migrate over here with the rest of their families, okay? All right, let's see what other questions I have. Okay, so I have a question from Ed Dorado, who's asking, do I have any idea when the embassies are going to resume DNA collection for F2 visa child of an American citizen? All right, thank you for your question. So any questions regarding the consulates overseas where you're wondering when you're going to have your interview, when are they going to go ahead and resume DNA collection and all those things, everything is going to depend on the local conditions of that consulate where your case is assigned. Now, we know that the COVID-19 pandemic is happening, and that, you know, as a result of the COVID-19 pandemic, there's a lot of slowdowns, a lot of closures. People are not working the way they used to. Did you know that in the past 1 year, in the past several years, almost 1,000 consular officers have not been with a job? It's a very staggering statistic, which means that consulates are suffering, and as a result, your interview and your process is going to slow down too. So it really depends on the local conditions of the country that the consulate's in. Okay, so I'm going to take some questions from TikTok. Let's see. So I have a question from Habib who's asking, if I live in the USA for 4 years and months, is it okay if I can apply for citizenship? So a common thing that people ask me is, can I apply for citizenship if I'm in the US? And what you should know is that there's a stepping stone to becoming a citizen, and that stepping stone is getting a green card. If you do not have a green card, then most likely you're not going to be eligible to even try for citizenship. Most cases, you need to apply for, you need to hold a green card for at least 3 years if you got your green card through marriage to a US citizen, or 5 years if you got your green card in any other way, including employment, including other family members. Okay. So I have a question from Myra who's asking, I've lived here in the US for 26 years and my mom brought me here when I was 1. I married a US citizen. Would I need a perdón? Okay, so Myra, thank you so much for your question. So I would say this to anyone who is married to a US citizen, but they were brought here as a kid. Now, one thing to explore is, do you have DACA or are you eligible for DACA? If you are eligible for DACA, then one thing that I'm recommending to some people is to try to get advanced parole. If you can get advanced parole, then you would be able to get a stamp in your passport that would serve as an admission and inspection into the US, and you can bypass the perdón process. But if you're not eligible for DACA, or you don't have DACA, or you cannot get advanced parole, you may need to do a perdón. And a perdón is basically when you have to prove that your spouse would suffer extreme hardship without you here. But one thing that I like to explore in a lot of my cases is to see, are you having any sort of marriage problems? Are you having issues in your relationship? Do you ever feel that you have been put down by your US citizen husband or your US citizen wife, where they're not treating you as an equal? They sometimes threaten, they sometimes say negative things about your immigration status or where you're from, how you speak, whether you speak English or not. Do they make you feel hurt in any sort of way? These are some things that I'd like to explore, because if the answers might be yes to some of them, then you might qualify for a different sort of case, which is the case that I was discussing earlier, which is VAWA, the I-360 for spouses who have suffered extreme cruelty. Now, I know that phrase might sound very scary, but there are a lot of problems that people go through in their relationships that they might think are normal, but underneath the law, they actually are. They actually qualify as something different that may help you get this green card process done here without having to leave the US and do the perdón. So I would love to explore to see if you qualify for it. So give us a call, 212-248-7907. And if you don't qualify for it, then yes, you would likely need to do the perdón and go overseas to your home country for an interview at the consulate. And what would happen is you would go through that interview, you would be deemed admissible to the US, you would be stamped in your passport with an immigrant visa. So the minute you step foot in the US, you're considered a resident and you can live and work here and apply for citizenship in the future too. Okay. Let's see what other questions I have. So from Miguel Jimenez is asking, can a son petition for mom and dad if they're here and he's a US citizen? All right, Miguel, yes, give me a call, because if your mom and dad are here, then you may be able to petition for them. Now, this is also going to depend on one important thing. What sort of entry did your mom and dad have? Did they come in through the border, illegally without permission? If that's the case, then I would like to talk to them to see if they are eligible for any other sort of humanitarian visa. Because if your parents did not come in legally through the border, then they're not going to be eligible to do an adjustment of status in the US unless they have certain other exceptions. So for example, if you yourself as a child are in the military or have been honorably discharged, then you may be able to help your parents get something called military parole in place. And that basically kind of wipes away that legal entry into the US. But if your parents have any other issues, like the permanent bar or any or prior removal orders, then they may not be able to get the military parole in place. Now, another thing that people don't always look at is, did your mom or dad ever have any siblings or any employer in the past that filed applications for them to get a green card in the future and in the past? And by past, I mean, was this application filed before April 2001 or by April 30, 2001? If their application for them was filed, then that may also help them adjust their status in the US, even if they came in illegally. Now, if none of these things apply, then I look at I look at 3 different types of humanitarian cases to see if they might qualify, and that is for the U visa, the T visa, and VAWA as well. Okay, so definitely give us a call, Miguel, 212-248-7907. So a question from Brenda who's asking, hi, what happens if my DACA expires before my renewal is approved? So I think if your DACA expires before your renewal is approved, you're going to have a lapse of deferred action, and also you will have a lapse in your ability to work. I don't think that it's going to impact your renewal. It might. If it does cause a denial, then you can always reapply with a new application. Okay. So let's see. I have a question from Moumita who's asking, my friend is married to a US citizen and her I-130 was approved, but was denied a green card due to removal because she did not appeal for her asylum interview, which was withdrawn. So Moumita, you can definitely give us a call, 212-248-7907. I'd be happy to take a look at your friend's case. She needs to have all of her records. So also, actually, this is very important for anyone who has been in any sort of immigration process, whether you've been in court, whether you have filed paperwork affirmatively with the immigration, with the USCIS before in the past for any sort of immigration benefit. Make sure you keep copies. Make sure you keep copies. Make sure you keep them organized. If you used a lawyer in the past, try to always get a copy of your paperwork in advance, because it's very hard to piece together what has happened in someone's immigration history and to figure out what they're eligible for unless we see the paperwork. So you should always retain copies of anything you submit to the government anyway, because this is your life, right? This is basically your life, and it's your information. So keep copies. Provide them to the attorney when you consult. I regularly ask to see a few different things. So anyone who consults with me, there are a few things that I like to see that help me help you understand what your options are. Number one are criminal records. If you have ever been arrested in the past, if you have ever had any sort of encounter with law enforcement, you need to get your criminal records. And what I mean by this is every attorney will need to see at least the one piece of paper that tells them what the final outcome of the arrest was. Was it really dismissed? Was it pled down to something less? Or did something else happen? That is the one piece of paper that we need to see for every single arrest that you've ever had. I don't care how old it is. It could be 20 years ago. It still doesn't matter. It's because it still matters for CIS and the immigration courts. Number two is if you have ever had anything approved or denied, then I would like to see copies of that too. And number two, if you have ever been told to go to court, if you have ever had any deportation proceeding, I would like to see something called the notice to appear. The notice to appear is the charging document that basically ICE or CIS has to give you that lays out the violations of immigration law that you're being accused of. It tells you the hearing date and the time and the location that you have to appear for court. And there's actually a really great Supreme Court decision that came out today, which says that the notice to appear is not considered a complete charging document unless all the fields are filled. So for those of you who are in court, go look up that notice to appear and make sure it doesn't say TBD on the fields, because if it does, then you might have grounds for something that would make you eligible for something called cancellation of removal in court. Okay. And thank you for your questions, Miguel. All right, let's see what other questions I have. Okay. Sukaina, thank you very much. Okay, so I have a question from, so I see that I have a lot of questions about NVC processing and visa processing. And I have one question about, is there a difference between documentarily qualified and documentarily complete? I believe that documentarily complete means that you have provided all the documents, but documentarily qualified means that the documents have been reviewed and accepted by NVC. I've had questions I have a question regarding Why the Bridgetown, Barbados Embassy is not opening for family-based petitions. Well, I want you to follow me on YouTube because I'm actually doing a lot of videos about the consulates and what's happening there. And if you are watching my YouTube videos, then you'll know that the chat with Charlie that they had last month, basically said that consulates are not going to be able to resume interviews like they used to because they just don't have enough staff. They don't have the ability to open. Things are going to be slowed down for probably years to come. Okay. Okay, I'm going to take one more question. Oh, Miguel, if your dad applied for 245I in 2001, definitely give us a call because then that may help your dad. Okay. Oh, I have one question from Brooklyn Guy. Who is asking, can a son petition for a mom and dad if they live in Mexico? I'm a U.S. citizen. Okay, yes. If you are a U.S. citizen and your parents are not in the U.S., can you petition for them? And the answer is yes. The answer is yes, you can definitely petition for them because your parents are considered immediate relatives. And they are not going to have to wait, beyond the normal processing time to get their visa done. However, their case still needs to be analyzed. Were they ever in the U.S.? Do they have a history of any immigration violations? Do they have any prior deportations or arrest history? These are things that still need to be analyzed. And even if they were here in the past, even if they have the 10-year bar, it may still be possible to bring them back. Sometimes they do have to wait out the full 10 years, but, in other cases, they might be eligible to get certain permissions to come back sooner, okay? So definitely, if you're looking to bring your mom or dad over, give us a call, 212-248-7907. We're doing lots of cases. I've got a really lovely case where we're working on bringing 2 sisters back through their kids, and it's really great. So, all right, so that's it. I'm very thankful to see everyone here. I hope everyone has a great day, and I'll see you next time.